The glaring feature of what the government has done in expanding this exemption is to toss to the winds entirely Congress's instruction that women need and shall have seamless, no-cost, comprehensive coverage. Seamless, no-cost, comprehensive coverage. This leaves the women to hunt for other government programs that might cover them, and for those who are not covered by Medicaid or one of the other government programs, they can get contraceptive coverage only from paying out of their own pocket, which is exactly what Congress didn't want to happen. And in this area of religious freedom, the major trend has not to give everything to one side and nothing to the other side. We have had a history of accommodation, with tolerance here, respect for the employer's workers and students who do not share the employer's or the university's objections to contraceptives. And every time we have dealt with this subject, we have assumed that there would be a way to provide coverage that would not involve any cost sharing by the individual. So in Hobby Lobby, we assumed that the self-certification was okay because women could receive coverage without any cost sharing by the organization, the group health plan, or the participant. And then in Wheaton, we said nothing in the interim rule affects the ability of applicants, employees, and students to obtain without cost the full range of FDA-approved contraceptives. And finally, in Zubik, we said we instructed the parties to endeavor to put in place an accommodation of the employer's religious exercise while at the same time ensuring women covered by employers' health plans, ensuring that women receive full and equal health coverage, including contraceptive coverage. So you have just tossed entirely to the winds what Congress thought was essential, that is that women be provided these services with no hassle, no cost to them. Instead, you are shifting the employer's religious beliefs, the cost of that, onto these employees who do not share those religious beliefs. And I did not understand RFRA to authorize harm to other people, which is evident here, that the women end up getting nothing. They are required to do just what Congress didn't want.
General Francisco, could you respond?
Yes, respectfully, Your Honor, I think I would disagree with the premise of your question, because there's nothing in the ACA, as this court recognized in Hobby Lobby, that requires contraceptive coverage. Rather, it delegated to the agencies the discretion to decide whether or not to cover it in the first place, and we think that that also includes the discretion to require that most employers provide it, but not the small number who have sincere conscientious objections, because otherwise the original church exemption likewise would be illegal, as would the effective exemption for self-insured church plans. But even putting
the church itself has enjoyed traditionally an exception. From the very first case, the McClure case in the Fifth Circuit, the church itself is different from these organizations that employ a lot of people who do not share the employer's faith. And I thought that Congress had delegated to HRSA for its expertise in what contraceptive coverage women would need.